lots of suits are beginning to pile up at the Federal High Court and Supreme Court of Nigeria, challenging the legality of some of the presidential candidates, the three major presidential candidates. The postulations of the suits are challenging the legality of Obi as the Labour Party flag bearer, and also the nationality of Atiku and Tinubu's age declarations and educational qualification. I am Olachi and welcome to 7 Legal. Today we'll be talking about why some of the suits are coming up at the verge of the campaign and a few months before the presidential election. With me to discuss this is Dr. Obinna Onia, Assistant Head of Chambers, Bazo Chambers. But before we get onto the show, let's go on a commercial break.
For advert placement, you can call the number on your screen.
And you can visit our website at www.7fm.tv.
7TV Nigeria.
7TV, it's all about you.
Welcome back. This is Olachi Anikwa, and you're welcome to 7 Legal. Like I said before, today we'll be discussing why some states are coming at the verge of 2023 presidential election and almost close to the campaign. And we need to discuss this is Dr. Obinna Onia. And how are you, sir?
I'm very well, thank you.
Okay, so I want to understand why are some of the states coming up at the verge of campaign and also the verge of the 2023 presidential election?
The starting point is that our election or the procedure for conducting elections in Nigeria are statutory. By statutory, I mean that they are guided or regulated by laws. The Constitution, the Electoral Act, and then down to the political parties, you have the guidelines of political parties. So, the Electoral Act is the most important document that regulates the process and also the activities of political parties. And for a person to aspire to the office, you restrict your question to that of the president. So for a person to aspire to the office of the president, the Electoral Act has provided conditions, okay, within which a person must conform with to be able to so aspire. And so in the expression of interest and nomination forms of every aspirant, the person will fill in some documents to show that he has met the eligibility requirements set out by the Constitution and the Electoral Act, okay, to vie for that office. Now, the Electoral Act now goes for that to make elaborate provisions for persons who have reasons to believe that an aspirant to an elective office has given false information or stated or given a false statement or has provided a suborned document, a forged document in satisfying the requirement for the office he vies for. So any person who has reason to believe that has a right to bring a suit before the Federal High Court to say that, oh, this aspirant is not qualified to vie for this office because he has not met this eligibility requirement, or because he has given a false statement, or because he has told a lie on oath. So these factors will disqualify such an aspirant from vying for the office. Now, the reason why you now see a surge in these cases is that these cases are, like I said, it's the procedure is statutory. So the Electoral Act has circumscribed the time within which a person can bring such an action. You couldn't have maybe 1 year ago, when neither Atiku or Tinubu or Obi were the candidates of this political party, you couldn't have brought a suit to say, oh, this person is not eligible because at that point, the course of action, okay, or the course you're challenging has not crystallized. The right has not accrued, okay? You can only bring an action when the course of action has become ripe, okay? If you brought it before they became the candidates of those political parties, you will say that those course of action are speculative, and the law does not deal with speculative issues. The law only deals with issues that have become, that has crystallized, that has been that are ripe for judicial intervention. So it is upon the completion of nomination, the nomination process, a party has conducted its primaries, then any person who has reason to complain about the conduct of those primaries now has 14 days by the Electoral Act, has 14 days
From the time he became
from the date of the conduct of the primaries to bring an action. If your complaint is about the outcome of the primaries, or if your complaint is about the publication of the name by INEC, okay, and INEC just did the publication a couple of weeks back, you have 14 days from the date of that publication to say, because it's at that publication you can now see the particulars of any aspirant who seeks to vie for an elective office. So you have an opportunity to go to approach INEC, request for the particulars submitted by, say, Peter Obi or Bola Ahmed Tinubu, and then say you go through those processes. If you say, oh, Peter Obi claims that he schooled in Oxford University, and you know that he did not school in Oxford University, but in his form he feel that he went to Oxford University, then you can bring a suit to say he has given a false information, okay, in his form, because he does not have that requirement he claims to have. Now that's going to be a disqualifying factor, okay. If, for instance, in Atiku's case, Atiku says he was born in Jeddah, in Old Gongola, yes, Old Gongola, okay, or you say it wasn't part of Nigeria, it's Nigeria, it's not Nigeria. Well, those are issues which the court is called to adjudicate over. So those are your course of action will start running from the date INEC either publishes his name, or he conducts, or the primaries that produce him was conducted. So these are the issues that are now presented before the court for adjudication. The truth of the matter is that the electoral process is an evolving system, and we must commend INEC. INEC has actually improved the process of nomination. The consequence is that suits being filed at the election tribunal after the elections are being reduced daily. So the best bet of people who seek to challenge an election process is to bring the action as pre-election, that is, before the substantial election next year, but after the primaries. So that's why you're seeing the surge in cases at this time.
Now, why are they having these assertions right now when these people have been in the elected position for some time?
Thank you. So that's a very good question. You see, two ways to look at it. One is that nobody knows it all. A person who has that information today will not be barred from bringing that information for the purpose of this election. That's one way to look at it. The second way to look at it is that politicians are getting more desperate.
I have more money to throw around.
Well, no, not necessarily more money to throw around.
Okay.
It is, for me, I believe it's a way to reinforce our judicial process and judicial system. I don't see a barrage of litigation as a bad thing. I see it as faith in the justice process, because if they did not have faith in the justice process, you won't see this number of cases coming up. So I think it's a vote of confidence in the judiciary that people believe that they can always get justice from the court, and that's why this number of cases are coming up.
So you're saying if the other side of the whole litigation means Obi might likely not vie for the position, and other people might likely not vie for the position of the president by the next coming election.
Okay, so to be specific to Obi, the issue with Obi is that there's an alleged two factions, or there is an alleged factionalization of the Labour Party. You see, that issue is easily dealt with for the reason that INEC recognizes only one faction. So the other parties are, forgive me, rabble-rousers, they are noisemakers. So there is one faction which INEC recognizes and INEC deals with, and it is that faction that Obi belongs to. So there can only be one leadership of a political party at the same time. So, but whatever the outcome is, in the event that the other faction, which I'm calling rabble-rousers, succeed, then naturally the primaries that would have produced Obi is void, is invalid, and therefore he cannot be the candidate.
So what you're saying that the suits against Obi as not being the legal flag bearer of Labour Party will not see the light of the day.
It really depends. But generally, I understand that a person is claiming that his tenure as chairman of the Labour Party is still valid and subsisting, and therefore he's the only person who could have conducted the primaries of the Labour Party, and therefore the persons who conducted the primaries or that produced Obi is invalid. Well, that matter is sub judice, and but the consequence, natural consequence of that suit is that if his suit succeeds, that the person who is claiming that Obi, the faction that produced Obi is not the valid faction, if his suit succeeds, the natural consequence is that Obi could not have been, cannot be the. However, like I said, the matter is sub judice, and it's for the court to determine one way or the other. But I believe that Obi would have done some due diligence and looked at, with his legal team, and looked at the health status of the Labour Party before the
there's a suit filed by Judge Uche San on behalf of the PDP. The party is claiming that the Electoral Act of 2020 did not make provisions for a placeholder or a temporary running mate. Do you think they have enough grounds for their postulations?
You see, that issue of placeholder is a generic term coined by the media. Okay, nobody has ever said that there is a placeholder. We needed a term to describe what was going on. At every point in time, a running mate was selected. What happened was that the running mate selected wrote to the party and said, "I'm no longer running." Okay, so the Electoral Act allows the political party to substitute a running mate. Okay, so because the law is made for man, we understand that if a running mate says, "I'm no longer running," the party will be allowed to substitute. We've always known that. So they took advantage of what the law says to say, "Oh, okay, I put Mr. A there while we are consulting." Okay, whenever they finish consulting, Mr. A now, because he understands that he's in quote what you call a placeholder. When the consultations are over, they say, "Okay, we're now using Mr. C." Okay, Mr. A now says, writes to INEC to say, "I no longer want to be the candidate or the running mate to the governorship or presidential aspirant. I want to resign." Now with that, INEC will now write to the political party to say, the running mate to your candidate has resigned. Select another person. Okay, so it's because we understood that this was just a waiting game. Okay, but on the books, on INEC's record, there is nothing like a placeholder. Okay, if for instance somebody wakes up tomorrow and says, "I don't want to run again," you can't force him to run. INEC cannot insist you must be the candidate. He has the right to withdraw from the exercise as long as it is voluntary. The most important thing is the voluntariness of the person who, in quotes, the placeholder who is holding that office. The day the placeholder say, we are calling it placeholder for the purpose of this, the media and the whole exercise. But in truth, the person has the right to resign, or if the person dies, or if the person becomes mentally incapacitated, the political party has the right to select another person. Okay, so the issue of placeholder is gossip. Okay, because we know that this is not the person the party wants, and then the person who was holding the place now withdraws. Okay, but that exercise is not something you can take to court for a court to adjudicate over, because INEC record does not bear out this fact. The risk they run with placeholder is that somebody may have been appointed placeholder, and then that's okay. We have chosen our candidate now. We are right to INEC to withdraw. The person will say, "I will not withdraw." You say, "No, now this is not what we agreed. We right to INEC." The person said, "I'm not withdrawing. I'm running. This race, I will run it to the end." Okay, that's the risk they run. Okay, but it's these are internal issues of a political party. So they will not bring a person who they are not sure of his character, okay, to say, because this is power. It's power people are fighting for. So a person who gets greedy and say, "I'm not going to leave this running mate, will run it to the end." Okay, the party is stuck with him. They can't change it. It's a risk. Okay, that's the extent of the risk they take. But with respect to say placeholder, I'm not sure any document bears the name placeholder.
So with all your analysis,
yes,
PDP is not going to win this case.
the case is speculative,
It's speculative.
and the law does not deal with speculation.
Okay.
It's not rooted in law and fact. Then where would they get the facts to support placeholder? Newspaper reports. Newspaper reports are gossip, and the court does not base its decision on newspaper reports. Okay, you must get documents from INEC to show that it was actually placeholder. In the absence of that, the case will crumble like a paper.
Okay, so there's another thing I saw. I said that the plaintiff, that's the PDP, they are also seeking for declaration that the office of the vice president is an elective one, with reference to section 84 of the Electoral Act. Is this legally true, and can it be binding? I don't know.
So when you say elective one, it's only elective to the extent of participating in the general election. The office of the vice president is appointed by the winner of the primaries. Okay, so it can only become elective when both of them go to the general election. So I don't agree that it's elective for the purpose of nomination. It's only elective for the purpose of the general election.
Oh, okay. So to dive out of politics generally.
Yeah.
So who do you think is going to be the winner of the presidential election?
It's so what I love the most about this exercise is that for the first time we have a good mixed grill of political activities. The PDP are experienced, they've been there, they've won some election, solid political party, solid candidates, solid structure. The APC are also in power, they have incumbency, they have solid structure, they have the funding. The goodwill, I don't know because Nigerians are not satisfied with the leadership of the APC so far. So they are riding the tide really with the spirit of insecurity, the economy. ASU has been on strike for half a year now, and going on and on. So the APC really has. I wonder what they will be saying at the campaign trail. I really wonder what they will be telling us at the campaign. The Labour Party is the wild card. They are the people to really look out for because they don't have a structure. But what I see is the protest vote for the Labour Party. Not because the people like Peter Obi as a candidate, as a person. Who cares about Peter Obi really? But it's about the electorate saying that PDP and APC has failed us. Let us go for a new person. Okay, and if Peter Obi becomes president and also goes the same line of the PDP and the APC, what was served on PDP and APC will be served on them. I think that will make for a robust electoral system. If the leadership of the country know that you mess up, you're voted out, then it will help to build, it's a wake-up call for them. It's a 4-year window for a person to get its acts together. Okay, and we must take advantage of that 4 years to deliver the dividends of democracy to the people. That's the most important thing.
Thank you very much, Dr. Obina. Sorry. Well, comrade, at the end of today's show, when lawyers tend to file suits, and I wonder why they do that, but today we've come to understand that the suits are to help democracy and electoral decisions and processes. I am Olachi Anyokwa, and this is 7 Week. Do have a blessed day. See you next week.